morning, Mr. Collins.
Good morning, my lady. May it please you, my lady, and your lordships, I appear for the appellant, my learned friend Mr. Curl for the respondents. And as you know, this is a case raising two important issues. The first is the proper realisation of assets in a liquidation, so that the office holder fulfills his professional duty and obtains the best price reasonably obtainable. And secondly, who can complain if that proper procedure is not followed? And now my learned friend, in support of the judgment below, says that there is no complaint here about the proper realisation of assets, and he says in any event that I'm not in a position to complain, because although I'm a creditor in the liquidation, because we were in the market for the asset, that somehow disables us and strips us of locus.
So the questions are standing, number
Yes.
one, and secondly, as you've said, best price, but another way of looking at that would be, in fact, whether the discretion, if I can put it that, the business acumen exercise of discretion of the liquidator was perverse.
Yes, that with respect, my lady, is quite right. Because when it comes to that second stage, if I have locus to complain at all, of course, it's not every case that's going to result in perversity, which then can give rise to a set-aside or something of that sort, because quite a few cases are mopped up by a simple claim for professional negligence if an asset's been sold at an undervalue, because an office holder is liable, can be made liable for breach of the common law duty of care. So this appears goes one step further, and your ladyship is right. In order to actually to set aside the transaction, one has to get into the sort of issues that one gets into trusts just the same way. It feeds across the whole of the.
And unless it's perverse, Mr. Collins, the question of the standing doesn't matter.
That's right.
Yeah.
That's exactly right. Now, can I go straight into Edengate? I haven't found it terribly easy to follow Edengate with all the references to S and A and E and so on. So I've reduced it to diagrammatic form. Could I hand this up to your ladyship and your lordships, please? So this was the well-known 1990s falling out between Mr. Sugar and Mr. Venables. And as one sees from the chart, Mr. S and V are Mr. Sugar and Mr. Venables. A Limited is Mr. Sugar's company. E Limited is Edengate, Mr. Venables' company. They were both shareholders in Tottenham Hotspur PLC, TPLC. The relevance of the double line from Mr. Sugar's side is that he had a larger shareholding in TPLC and therefore had control of it. And Tottenham Hotspur PLC in turn owned Tottenham Hotspur Limited, which was the playing club. And Mr. Venables had a service agreement with TPLC, and his company had a management agreement with T. And after the falling out, there were in fact two sets of proceedings. The one set of proceeding was where Mr. Venables and E Limited brought an action in the QB against the respective counterparties to their agreements. And there was in fact also, and this is how TPLC ends up as a creditor of Edengate, there was a Section 994 petition in the context of TPLC, which resulted in an adverse order for costs, and a cost order in favour of both TPLC, A Limited and S. And so they were all creditors of E Limited. And there was an application for security for costs in the QB action, which seems to have caused some consternation, although one's not quite sure why, because if there was an individual in the action as well as the company, an order was unlikely to ensue. But this prompted a great flurry of activity. And TPLC wound up E Limited, as you can see, in May 1994. And just before the application for security for costs was coming up again, in July 1994, the liquidator of E Limited assigned E Limited's claim against T Limited to Mr. Venables. So he then, as it were, became the sole claimant in the QB action in relation to both his own service agreement with TPLC and the management agreement with T Limited, whose claim was assigned from his company to him. And then we have the judgments of the court in relation to this, when the application was made by S, A Limited and TPLC, all creditors of Edenode, to set aside that assignment. So that's how it comes about. May I first turn to the judgment of Sir John Vinelot to just pick up a couple of the facts in the case, which is tab 1 of the bundle, or if you're using the electronic version, page 15. I want to go to first. So this is the judgment of Sir John Vinelot on the application that was brought, and on page 15 of the using the electronic bundle numbering in the bottom right-hand corner, the assignment came to light, and we see at just near the first punch hole between F and G that the letter was sent to Herbert Smith, who were the solicitors for the sugar side, not as solicitors for the applicants in their capacity as creditors of Edenode, but as solicitors to Tottenham and PLC and Tottenham Limited in their capacity as defendants in the QB action. Herbert Smith were told the liquidator was in the process of assigning Edenode's claim, and that notice was being given to them to avoid unnecessary costs incurred in relation to the application for security for costs. However, in their reply, Herbert Smith made it clear that they were concerned that any assignment of the claim might prejudice their client's position as creditors, and at the fact that no one except Mr. Venables had been approached to see what he was prepared to pay. Clearly the objection was that neither T Limited nor TPLC had been approached. There was no other potential purchaser. They posed a number of questions, which the writer, Mr. Watts of Herbert Smith, said had been put to Mr. Saville in the morning, where was anyone else approached, and so on. And then over the page, there's some correspondence, and at E there is a letter from Herbert Smith again to Rothman Pantel, which is the Rothman Pantel were Mr. Ryman's firm, that's the liquidator's firm. They instructed Navarre and Nathanson. What's said in Herbert Smith's letter at E? We'd have thought that it was an obvious course of action to approach the defendants in the litigation to see whether or not they would, in effect, be interested in settling the litigation. Without making such an approach, how can the liquidator be assured that he's acting in the best interests of creditors as a whole? And then at the bottom of the page, Herbert Smith also pointed out, to act in the best interests of creditors as a whole, your client should have secured the best consideration possible for the claim before disposing of one of Edenode's two assets. It may well have been that our clients, if approached, would have offered a sum which had exceeded the nominal payment made by Mr. Venables. So the interest of Herbert Smith acting for all of Mr. Venables, A Limited, TPLC, and T Limited was that they were in the market because a claim was being brought by E Limited against one of the companies, namely T Limited, to which TPLC was also a party, albeit on a different cause of action, because the claim against TPLC was brought by Mr. Venables under that service agreement. So it's not quite the case where, it's not quite the vanilla case that we have before us, where my clients are the only defendants or my client is the, although there are other defendants which we'll come on to a claim. But it's all about the fact that there are people in the market. And what a liquidator has to do, a basic thing, is to test the market properly. I mean, if he's selling a property, that's easy. he can go on Zoopla, he can put it in a local auction or something of that sort. But this is an asset like any other, and it's absolutely obvious that a target of a piece of litigation is in the market for that piece of litigation. And in this case, it was obvious that that the sugar side would be interested in purchasing this in order to try to get rid of the litigation. It wouldn't get rid of it entirely because Mr. Venable's claim was still there. But they were obviously interested in it. And the reason that they were doing this was, of course, they're creditors, but the only reason they're interested is because of the litigation. And that, as we'll see from the Court of Appeal, did not disable them from complaining that, as creditors, that a proper procedure had not been followed.
You say the only reason they're doing it is because of the litigation. I don't at the moment understand what the significance of that is in your argument. Can you just explain?
Well, it's simply that Tottenham, that TPLC and T Limited weren't in the market for this cause of action because they were a litigation funding company or something of that sort. They were only interested in all of this because they were defendants in a claim which was brought by E Limited, and it was that cause of action that was assigned by the Liquidator of E Limited to Mr. Venables. And as defendants to that litigation, they say that they were also in the market for it. And as it's said in that of course, if you buy a cause of action that's being brought against you, you in effect settle it because you don't sue yourself. I mean, it's something of a misnomer to say that if you have a cause of action against yourself and you don't bring it against yourself, that you've settled the cause of action. But the effect, of course, is the same. And that's why they were interested. And the obvious people who are interested in a shows in action are the most obvious people who are interested in it are the targets to it. Are the targets. But but we'll see from the authorities that there are other people who may be interested in a cause of action because of the circumstances, and they are therefore in the market, and the market should be tested. And if the market isn't tested, that's wrong. And if they are also creditors in the liquidation, they can complain about it, and they have lockers to do so. Even though the only way that the liquidation could benefit is by them themselves paying more money for the cause of action than somebody else. But that's the entire effect of Eden Note and a subsequent authority in this court of ultraframe.
So your submission then is that status as creditor gives you standing,
yes,
even if your status as creditor is entirely fortuitous.
Well, it's yes, you can put it in that way, my lord, because the law is that, and that we'll come on to a case of her ladyship's presently, a case called Break and Lowe's, where a bankrupt also had lockers to make a complaint in this regard. But that is right, and for the good administration of liquidations, it's perhaps unfortunate that any disappointed bidder can't take issue with a liquidator not following the proper course. But there's another rule which provides that you have to have a legitimate interest in the liquidation to be able to complain about it, and so that liquidators aren't vexed by, as it were, complete third parties to the liquidation. But if you're an unsecured creditor in an insolvent liquidation, you couldn't be more interested in the liquidation. But what the learned friends...
But your interest is to maximise, not to minimise the
Correct.
return.
That's exactly right. That's it. Your interest is to maximise the assets in the liquidation. In which case, if an asset is being sold, namely in this case a shows in action, it should be sold in a proper way and the market for it tested. And of course, in this, in Edenote, it simply wasn't. It was just sold willy-nilly to Mr. Venables without going to the far wealthier parties, frankly, of Mr. Sugar and his companies, as to whether they'd be interested in acquiring the cause of action. And we'll see that the trenchant way in which the Court of Appeal upheld Sir John Vinelott's setting aside of the assignment well, now it's tab 2, page 26 of the bundle. Now, this...
Would you agree that the central feature of it is that involving the sugar companies gave rise to a real or realistic prospect of increasing the value of the asset?
Yes, they were...
And that's the central feature?
Yes, it is.
And it's necessary?
That's right. Because well, that's exactly right. Because if somebody were to come along and say, well, you should have offered it to me, but I wasn't going to buy it, then it would be a pointless exercise. That's not my client's position at all. So yes, there has to be a realistic market. I'm not also saying that this is an absolute rule. One example of it not being absolute may be where a liquidator is it has a claim against directors for misfeasance, but is unable to pursue it through a lack of funds. And there is a very strong argument for interlocutory relief against the director, a freezing order or something of that sort. Now, of course, in those circumstances, it would be quite unfortunate if he was obliged to go to the director as the target of the litigation and say, well, I'm thinking of of assigning this claim to a litigation funding company like Manolete, and I'm giving you the opportunity to do so. And
why is that unrealistic? On your formulation, that's exactly what he should do.
But I hope I just submitted, my lord, that my position is not absolute. There are going to be circumstances in which the plain facts in the present case may be well obtained, but they'll be exceptional.
I mean, your freezing order example presumably is where the liquidator doesn't even want to tell the defendant that there is a claim.
Quite. Because
the assets may be squirreled away.
Quite.
And therefore you say,
Quite.
well, can't be expected to offer the claim in those circumstances.
That's not this case here. There was a substantial correspondence in the, well, not with my client, but certainly with other defendants that claim my client's parents prior to this. So that exceptional circumstance doesn't arise. But the basic principle is that a liquidator should offer, should test the market properly for any asset that he sells, and when it comes to a shows in action, which is a particular sort of asset with requiring care, he needs to find out, and it's usually obvious, who would be interested in acquiring that shows in action. And the most obvious person who'd be interested in acquiring the shows in action are the targets of the shows in action, which is my client in this case. But there are other people who would be interested in the shows in action because of the circumstances, and we'll see that in Lady Justice Arden's judgment in Ultraframe shortly. Now, could I turn to Edenote in the Court of Appeal? Because, I mean, this is really the start and end of it in our submission, because our case is indistinguishable from this case. His Lordship below said that Edenote had been overtaken or by other authorities. The way that his Lordship put it was that yes, it's been established since Edenote and so on. The way that he put it, and that comes down to the legitimate interest test. That's in fact paragraph 31 of his Lordship's judgment below, which is page 69 of the core bundle. But in our submission, when it comes to lockers, his Lordship was dazzled by the learned friend's great industry, and I was outgunned by it, frankly. But Edenote remains good law. because Edenate itself makes the point that it's not anybody who can complain. It's not any disappointed person having contact with the liquidation who can complain. It's only somebody with a legitimate interest in the liquidation who is a creditor. And the law subsequent to Edenate simply applies that principle. So there's been no change in the law. And I think that diverted his lordship below. And so Edenate in our submission remains a strong and correct case. There are no other authorities which are contrary to it. On the contrary, it's been applied many times, including in this court. There's no higher authority, and it's certainly not per incuria. Now, if we look at the judgment of Lord Justice Norse, with which Lord Justice Millett agreed, this is page 28 of the bundle. And this picks up your ladyship's point. At just below G on page 28, referring to the judgment of Sir John Vinelord, you see between G and H that his lordship said that the question he had to decide was whether the assignment should be set aside as an improper exercise of the liquidator's power of sale. And that's where we get to your ladyship's point. And the point is also made at just below H that Mr. Venables, there was no argument that Mr. Venables had been a bona fide purchaser for value without notice. Now, you will notice in this case that my claim is only brought against the liquidator and not, in fact, also against Manolete, unlike Edenate. But there's no point taken about that. His lordship dealt with it at the beginning of his judgment. He said that if Manolete had a separate point to make, for example, that they were a bona fide purchaser for value without notice, they could do so hereafter. In fact, Manolete had put a witness statement in saying that if this goes wrong for them, they're going to adopt a different course. So they're fully aware of all of this. And in fact, somebody from Manolete, I think, is in court today. They've been served with all the papers. So this point of principle can proceed. We then see on page 29 the reference to, at G, the applicants TPLC, A Limited and secured creditors of Edenate. And at G, they were persons who claimed that if they had been approached by Mr. Ryman, the liquidator, before the assignment was made, they might well have made a more valuable offer for that shows in action than Mr. Venables. Edenate shows in action being the claim, the up and running QB claim against T Limited under the management agreement. Then there's reference to sections 1673 and 1685, and reference to Mr. Rayner James' submission. He appeared for Mr. Venables between H and I, that the function of 1685, although it didn't avail the 1685 did not avail the applicants because they were not persons aggrieved within that provision. I mean, on the face of it, 1685, of course, is extremely wide. Person isn't defined, and they can be aggrieved in any number of ways. But the way that it has been interpreted for many a long year is that for a person to be aggrieved by an act or decision of the liquidator, they have to have a legitimate interest in the liquidation, and therefore they essentially have to be, for the most part, an unsecured creditor. And then his lordship deals quite trenchantly with the argument of Mr. Rayner James that the applicants didn't have lockers at below I. Quite apart from the improbability, not to say the absurdity, of the applicants being unable to apply to court in circumstances such as these, the construction of those sections urged upon us by Mr. Rayner James is contrary to that plain wording. And then picking it up on page 30 at just below D, it's neither necessary nor desirable to attempt a classification of those who may be persons aggrieved by an act or decision of a liquidator in the winding up. On the footing that the claims of unsecured creditors have been or will be satisfied, it's perfectly clear that unless and until there proves to be a surplus available for contributories, persons aggrieved must include the company's unsecured creditors. If the liquidator disposes of an asset of the company at an undervalue, their interests are prejudiced and each of them can claim to be a person aggrieved by his act, because there's a breach of his duty to obtain the best price reasonably obtainable. Mr. Rayner James submitted that the applicants brought...
So the significance of the legitimate interest which an unsecured creditor has is not simply that they are an unsecured creditor, but that they have an interest in maximising the recovery.
Of course, because that's their only interest as an unsecured creditor, and that is to swell the estate so that they get a better pence in the pound return.
And by they, in that sentence, you mean the creditors as a whole?
Yes, absolutely. Yes, all creditors. And of course, in this case, the applicant, the applicants, including TPLC, were creditors of Edengate, and even though the only way in which their interest in the estate could be swelled was by them paying more for the shows in action, his lordship did not deprive them of locus to make that argument, because not only them, of course, it's others. And we then look at we then consider the dual capacity point, because of course TPLC is not buying, it doesn't want to buy this cause of action out of the goodness of its heart, or because it's a litigation funding company. It wants to buy it because it's involved in litigation, where E Limited, the claim brought by E Limited, is being promulgated. And so that is where you have the dual capacity point. Mr. Rayner, between E and F, having just dealt with the point about creditors being able to complain about sale of an asset and undervalue, his lordship says such was the position of the applicants here. Mr. Rayner James submitted that they brought the application not as creditors, but as persons who had not been given an opportunity to make an offer for the asset. In the latter capacity alone, like any other outsider to the liquidation, they would not have had locus to apply under 1685. But even if that were wrong, they would have been able to apply in a dual capacity. So it's not any disappointed bidder or any potential target to litigation who can complain that there hasn't been proper marketing. It's only somebody who, as your lordship put it, also happens to be an unsecured creditor. And being an unsecured creditor gives you locus, and the fact that you're also interested in a dual capacity does not strip you of that locus. And this is the reference to outsider to the liquidation is the additional qualification or filter point, or as it's been put in authorities, a judicial constraint point. And that is the one that my learned friend developed by reference to subsequent authority. But it's in Edengate, and it's always been the law. And
is there a dispute between you that there's two aspects that the court is concerned about? One is jurisdiction, properly so called, which is what you're talking about. Are they a creditor? Because if they, for the present purposes, if they're not a creditor, they're an outsider. And then, which may matter more in this case, there's what you've just called the judicial restraint case, which is talking about the propriety of the interest that they're seeking to exercise. Is there any dispute? I mean, that's how I understand the analysis is advanced.
There's no dispute.
No dispute.
There's no dispute that my client is a creditor.
But is there any dispute that it's a two-stage exercise for the court? Standing is a two-stage exercise, however you describe it.
No.
Well, I'm not quite sure what we're arguing about.
Well, I think what we're arguing about at the second stage is that the additional qualification or filter, the judicial constraint phase, somehow completely disables my position of locus as a creditor. That's what was found below, because I was found not to have locus.
Is the question at the first stage, are you a creditor, or is it, do you have a grievance? That's what the statute says. And obviously your client does have a grievance. She thinks she was unfairly treated. But it's at the second stage you say, well, is that a legitimate interest? Is it to do with being a creditor seeking to maximise the recovery from the estate? Or is it entirely unconnected? She wants to kill off this action against her and her family.
I think it is if one looks at the test of person aggrieved, I think one probably distills it simply to a question of locus, and then a question of, if you have locus, do you have a grievance? Although I accept that if you don't have a grievance, the locus point would fall away. I need to deal with both hurdles. And for locus, what you have to be is a person who has a legitimate interest in the insolvent estate. It doesn't always have to be a creditor. It can, in the case of a bankrupt, be the bankrupt. But in most cases, it is a creditor, and they are the people who are most keenly interested in insolvent estates. And yes, my lord, I say that is it. But then my learned friend below, and the judge accepted, developed this point about, which of course I accept, that you can't be an outsider to the liquidation, and elevated that to the fact that, on the basis that the only way in which the estate could be swelled is if my client bought the shows in action for more, that somehow disabled her from having lockers. And I'm afraid I simply don't understand the point at all. And it's certainly not what happened in Eden Note.
Forgive me for being so picky. I think what you said was, for locus, you have to have a legitimate interest in the insolvent estate.
Yes.
That seems to me to be slightly ambiguous. Would it be fair to say, for locus, you have to be exercising a legitimate interest in the insolvent estate?
I'm not sure, my lord.
Because you're tending to run the two, what I described as two parts, together. If you're going to run the two parts together, the mere fact that you might, in the abstract, have a legitimate interest ceases to be determinative. What matters, surely, both on Eden Note and the subsequent authorities, is whether you're exercising a legitimate interest or seeking to exercise a legitimate interest.
Yes, my lord, your lordship is right. Because there is a case which we will look at where a creditor in the sum of 230.
That's the solicitors.
Yeah.
was seeking to interfere in an adverse way in the insolvent estate, and the judge said no. And indeed, your ladyship had the same in the break case, because when it came to the 1685 point, the creditors who were, as it were, bringing the 1685 claim were effectively had been put up to it by the breaks, and they weren't doing it for their own purposes. They were doing it for a collateral purpose. And in fact, when one does the arithmetic in break, it's also adverse to the estate what they were arguing for, because of the way the figures work with the sale of the property. And that's also an important way of testing it, because yes, of course, prima facie, an unsecured creditor has lockers, but there are ways in which, on the facts, the exercise of that locus it can be impeached, as it were, because it's not in the interests of the liquidation, either because they're just not doing it as a creditor, but more obviously the test is because they're seeking to do something adverse to the liquidation. In Lord Millett's opinion,
like the Deloitte case.
Exactly. In that case, there was locus, but because the relevant person was much wider, but what they were seeking to do was adverse to the liquidation in their own interests. It was in no way in favour of the liquidation. It's the same for the solicitors with the £237. They weren't interested in the position as creditors, and you could see that from the fact that they were trying to do something adverse in the liquidation. Now, my client...
You have to say that Walker Morris is wrong, don't interrupt you.
No.
At least, it seems on the face of it to be inconsistent with your widest submission so far, which is that status as a creditor gives you standing. End of case.
I hope I wasn't quite that absolute, because I do accept that I hope I submitted that your status as a creditor prima facie gives you locus, but that you may be purporting to exercise your interest as a creditor, but in fact doing something quite different. You may be doing it for a collateral purpose, or as in the break case, and you may be doing it for, and indeed in the Walker-Morris case, or you may be doing it, or you may be doing it, and usually this is the test, in a way that is adverse to the insolvent estate, so that and that's where the cases can usually be tested. The result is always adverse. It was adverse in Deloitte and Touche and Johnson. It was adverse in Walker-Morris, and it's adverse in the Brake case. So although they were purportedly exercising a jurisdiction, although they prima facie had locus and were purporting to exercise it, in fact they weren't. Now, in my case, and in Edengate, there's no way that this is adverse to the liquidation, because all I want is, and all that the liquidator should do, is to get the best price for an asset, and that can't possibly be adverse to the liquidation.
What do you say about paragraph 79 of the respondent's skeleton, which seems to me to encapsulate your difficulty quite nicely?
Right.
I think it's 79. Yeah, 79.
Well, in my submission, this just completely misses the point and is completely contrary to Edengate, because this is the way in which the learned friend says that my prima facie locus is somehow stripped from me because I am seeking for there to be a proper process for the realisation of a shows in action, where I'm a target.
No, what he's saying is what you're trying to do is to protect the debtor or the potential debtor, the forests, and also yourselves.
Well, of course we are. That's why we're in the market. My client, Mrs. Lock, is not a litigation company like Manolete, nor is she somebody who just goes around willy-nilly collecting causes of action to make a nuisance of herself. Not that she could do, because she's not a creditor of any, or any other liquidations. But of course, the reason that people are in the market is because they are targets or defendants to litigation. But that doesn't make any difference. It certainly didn't in Edengate, because that's precisely what was being done. It's all about the best price for an asset, and that's where we get into Lord Justice Norse's dual capacity. Of course, the TPLC as a creditor was interested in the shows in action in Edengate because it was a defendant in the QB action. There wasn't a great deal of altruism on its part. And the plain fact is that the only way in which its interests as a creditor could be improved would be by it paying more for the shows in action and it swelling the insolvent estate, in which it then gets a bit of a return, so it gets a bit of its money back. But that's not a disablement.
Doesn't this really show that standing and perversity come down to much the same question? In Edengate, you've accepted that a critical point was that there was a real prospect that there would be a better offer. Whereas here, is there any evidence of which the liquidator ought to have been aware that there was a real prospect of a better offer from your client? Because if there wasn't, then it might be said she neither had standing nor any prospect of showing perversity.
I'll come on to the liquidator's entirely faulty reasoning process in a moment, which was criticised by the learned judge below. But the liquidator never gave us never even considered, let alone gave us the opportunity to bid for this shows in action.
You could have done so at any point.
Well, my lord, that's a point that he makes. He says that he effectively says that, well, I said I was minded to give it to a
No. My point is entirely general. You could have bid at any point.
Well, what I would say about that, my lord, is that this is not an entirely straightforward field, and it is not for unsecured creditors or who may be also targets to litigation to understand the intricacies of purchasing shows in action or taking assignments of claims, or to understand the market that's grown up with litigation companies such as Manolete, and for them to go to the office holder and say, you need to do your job properly in this and that and the other way. It's for the office holder to do his job properly in our submission. He is a licensed insolvency practitioner and a fiduciary, and he should take heed of cases like Edengate, which make the points in a prima facie way that first, in relation to the sale of the shows in action, the market must be tested, and the most obvious person in the market is the target of the claim, apart from somebody like Manolete. And the targets are the only people who weren't considered in this case.
And so, to cut a long story short, Mr. Collins, you say your clients were unsecured creditors, and there was nothing else which should have filtered out their right as persons aggrieved, because if they paid more, or there was the opportunity that they would pay more, then inevitably that swells the coffers, and hey presto, and there is no other factor which disqualifies them from having been within the pool of those who ought to have been able to bid. And that going on, you say it was perverse not to ask them about it, and that's something you're going to come on to. But I think you've done the first element.
Thank you, lady. Yes, because and the best way of testing of that last thing that your ladyship said was that we were not seeking to do anything adverse to the liquidation, because the sale of a shows in action for more is something which is beneficial to the liquidation, and all the other cases are where there have been matters which are adverse. And so, coming on to perversity, we deal with it's conveniently on page 31. Can I just add this in relation to market? Although because my client was the target of the claim, the market, as it were, is obvious. In the ultra-frame case, her ladyship's case in Lady Justice Arden's case in ultra-frame, and here this is part of my learned friend's skeleton argument, which I would respectfully commend. Ultra-frame is not at all easy to follow, as a matter of fact, but my learned friend has done a beautiful job of explaining in about a page and a half about ultra-frame. And he's made a very good point in his skeleton argument about how the cause of action which was assigned in ultra-frame was because there were two warring factions with well, you know the size of Mr. Justice Lewison's judgment in one of these things. There were two warring factions, and essentially the certain assignments of, I think it was IP rights, went to one warring faction, and it should have been offered to both. And her ladyship dealt also again with dual capacity. In that case, Mr. Snowden, who then appeared, accepted Edengate, and her ladyship said that he was quite right to do so. Now, coming on to perversity, on page 31 of Edengate, having concluded in as trenchant a way as he had observed before that at the top of the page that his lordship was in no doubt the applicants had Locker's standard. He then deals with setting aside the correct test, and I needn't go into all of this because there is no argument but that it's a perversity test. So it's a high test, and Eden Note is quite often now the authority that is used for that perversity test. But if we look at the bottom of the page, in the paragraph at the bottom, that said, it is certainly possible for a liquidator to do something so utterly unreasonable and absurd that no reasonable man would have done it, simply by selling an asset of the company without taking into account the possibility that a third party might well have made a better offer than he to whom it was sold. That's what Sir John Vinod found that Mr. Ryman had done in this case. And he applied the right test and so on. So we then look at the facts of setting aside and picking it up perhaps towards the bottom of the page, just below G. The judge's reasoning can be...
I'm sorry, I'm not with you.
Page 32, my lady.
Thank you.
I'm much obliged. The judge's reasoning can be summarised by saying that he thought that it ought to have been obvious to Mr. Ryman that if Mr. Venables acquired Eden Notes and limited cause of action in the QB, it would give him a very considerable nuisance value in the settlement of the action. So Mr. Ryman ought to have inquired from the applicant solicitors whether they were prepared to make a better offer than Mr. Venables. In other words, it ought to have been obvious to Mr. Ryman that he should make that approach by signing the cause of action of Mr. Venables without first doing so. He did something so utterly unreasonable and absurd that no reasonable man would have done it. Mr. Rayner James submitted the judge's finding as to what ought to have been obvious to Mr. Ryman was unjustified, principally on the ground that the applicants had never given an inkling of their willingness to settle. But his lordship seems impressed by that. And that's a point which I ought perhaps to pick up in the context of the observation that my Lord Justice Stuart-Smith made a few moments ago. And that is that we could have done something at any time, which was more in the context, my Lord, I think, of we were the ones who could have promoted the office holder. I'm obviously putting your Lordship's point back in a rather tendentious way for the sake of argument. We're the ones who ought to have reminded the office holder of their duty to get the best price reasonably possible by testing the market for this shows in action. But a point that's also made is, well, we had letters before action, and we could have come up with an offer, and that would have made it go away, i.e. to settle it. Well, our respectful point about that is that we don't think that there is a valid claim against us or our parents, and the proceedings are being resisted. In which case, why should we make a settlement offer in relation to a letter before action when we don't think there's a valid claim? However, there is, we would respectfully suggest, a world of difference between a letter between not entering into a compromise pursuant to a letter before action and the assignment, the sale of that cause of action to a claims litigation company. Because we know, because Mrs. Lock was involved, as the evidence shows, Mrs. Lock was involved in some litigation concerning this company, which the company was successful in. But as she said, she found a rather traumatic and expensive experience. And so she knew, and frankly, I think this is probably something which most people know, is that when a litigation company is going to get hold of a claim like this, even if you're successful, it is going to cause you untold nuisance, and you're not going to get all your costs back, let alone the trauma of the whole thing. And that has a value, and that's why targets to litigation, even though they don't think that they're liable in the litigation, there is a real value to them buying that shows in action just to make the whole problem go away.
And the same reasoning applies, I'm sorry, whether it's settlement or whether it's taking assignment. It's exactly the same point.
Well, it's the same result, but they're quite different procedures.
It's the same logic. It's exactly the same logic.
Well, my lord,
because what the target does, whether with a view to settlement or obtaining the cause of action, is to evaluate at whatever level they wish to, A, the risks of success and failure, B, the risks of or not of recovering costs, and C, the traumatic effect of having to go through litigation. Those features are exactly the same, I would have thought. whichever route you're adopting.
Well, not quite, because when my clients, as the evidence showed, well, in fact, my client was never approached. Mr. and Mrs. Forrest were approached with a letter before action. My clients never were.
No, but
If you're making that point, the liquidator says it is improbable that her parents did not pass a copy of it to Mrs. Lock, and although she has put in a subsequent witness statement taking issue with almost everything that the liquidator says, the one thing, as far as I can see, that she does not take issue with is the fact that the letter was passed to her. First question, is there any evidence from her that the letter was not passed to her?
Of course, Mrs. Lock knew that that this claim was intimated against her parents, which is why she instigated the meeting with the liquidator, having taken some informal advice.
No, this is 21st May 2019, where the liquidator says in terms, if you don't settle, the claim is going to be assigned so it'll be pursued against the parents.
The answer to your lordship's question is no.
So although she might not have liked the idea of settling the claim for essentially cosmetic reasons, she didn't think it was a good claim and therefore didn't want to settle it, there was absolutely no reason on the evidence why she couldn't have said, well, let us buy the claim or see if we can make a better offer instead. But she didn't.
The problem with that, though, my lord, is that was only a claim against her parents. And so even if she was aware of the 21st of May letter, that was the only claim that had been intimated was against Mr. and Mrs. Forrest. No claim was intimated against Mr. and Mrs. Lock until the letter before action against them, which was after the assignment had taken place. And so far as Mr. and Mrs. Lock are concerned, the liquidator never raised an issue until February 2020 against them. They raised an issue against the parents, and that was the first letter which prompted this meeting. And my client took some informal advice. And in fact, the perversity in this case is a fortiori, because there is evidence which the liquidator says he doesn't remember, but he doesn't deny that the prospect of buying a claim was actually raised at that meeting, as recorded in Mrs. Lock's handwritten notes, because she'd taken some advice from an insolvency practitioner before, a former insolvency practitioner, before she went to that meeting. So the liquidator was even aware of a potential interest in relation to all of this. Not that that should make any difference, because he should do it per se on the basis of Eden Note and conducting a job properly, unless there are exceptional circumstances which dictate that he shouldn't. But then what happens is there is the 21st of May letter, where this point is floated in the last paragraph. But that comes back to my Lord Justice Stuart-Smith's point, and my response to that is, it is not up then to individuals who are not insolvency practitioners, not well versed in all of this, and this is not a straightforward area, then to go back to the liquidator and remind him of Eden Note and say, well, you ought to make a proper bidding process, or at least do your job properly for getting the best price reasonably obtainable. That is not a substitute for the liquidator doing his job properly. And if he doesn't do his job properly, he is being perverse, according to Lord Justice Norris.
Can I be completely clear about what you've conceded? You've conceded that there is no evidence that your client was not aware of the terms of the letters, and my lord was specific
Correct.
about 21st.
The letters to her parents.
So far as the liquidator is concerned, can it be said to be unreasonable for him to assume that the Forrests and the Locks were acting in concert, and that the Locks would be aware of his letter?
Yes, I think it can be, my lord, because this is, again, this is just not a this is just not a proper process for a professional to follow. You can't write to one person on the assumption that it's going to reach somebody else. You need to have a proper procedure. And if a claim is going to be intimated against somebody, you can't intimate it against their parents and just hope that they're going to have a chat round the table and say, oh, one's probably coming your way as well. It's got to be done properly and formally, in just the same way as this cause of action, this asset, should be sold in an orderly fashion in order to obtain the best price reasonably obtainable. And Edennote says, prima facie, that means going to somebody who's in the market for that. And TPLC was in the market because it was a defendant in the QB action, and we're in the market because we're the defendants to the action being brought.
I think we've followed therefore what you say. You say that therefore it's inevitably perverse because the liquidator didn't ask them, and Edennote says he should have done QED. But is that sufficient for it to be perverse? Does one not look at perversity not just on the face of what it says in a paragraph in Edennote, but on the actual facts before the liquidator? And therefore do you not have to go on to look at those facts and to submit that actually this liquidator, in the circumstances in relation to what had been said about impecuniosity, etc., was perverse?
Yes, and in fact, when one analyses the liquidator's stated reasoning, the position gets even worse. And so,
okay, let's go there.
Could I do that by reference to the judgment below, which is at tab 3 of the
Six.
Tab 6 of the core bundle. And the reasoning, this is on page 74 of the bundle, page 13 of the judgment. The reasoning which the liquidator gives is in paragraph 20 of his witness statement. And he sets out 3 reasons in that, which his lordship says, Mr. Collings submits that this is an unsatisfactory explanation, and in my judgment he's correct to do so. First of all, his lordship agrees with me that where he says at paragraph 20.1, the respondents to the main proceedings were well aware of the claims, including as a consequence of having seen the letter to Mrs. Lock's parents dated 1st of February 2018. Now, the point there is that the reference to claims is, of course, the claims against everybody. And this picks up the point that I answered rather trenchantly a moment or two ago, that making a claim against Mrs. Lock's parents does not automatically mean that there's a claim against Mr. and Mrs. Lock, and nor should there be a presumption that it's going to be. And so his lordship's acceptance of my criticism of that is, in my submission, quite correct at paragraph 48. Then the next is at paragraph 20.2, Mrs. Lock's emphasis on impecuniosity. And his lordship is not impressed by that at paragraph 49, and in my submission, quite rightly so, because first of all, it was quite some time. It was quite some time ago. Secondly, it says nothing about Mr. and Mrs. Forrest, because they're targets to this as well, and they should have been canvassed. Indeed, the canvassing in this case that should have taken place in order to test the market is a fortiori, because here there were two different people in the market from whom there might be benefit. Because if the Forrests were told that this cause of action against them was for sale, the liquidator might have divided and ruled. And Mr. and Mrs. Forrest might have said, well, we'll buy the cause of action against us, and I'm afraid our daughter and son-in-law are going to have to fend for themselves. And he might have done doubly well if he'd actually got round to selling this in any way. And there's no question about, there's no issue about what might be the impecuniosity of Mr. and Mrs. Forrest. And in any event, if they're all so poor, I don't know why Manolete are now suing them for 1.2 million. And then paragraph 20.3, which we see on page 74. In any event, after the assignment had been negotiated in principle, Mrs. Lock's parents were put on notice, and that's the 21st of May letter, and you already have my answer to that, that it is not appropriate to put the burden of the proper conduct of this insolvent estate on these individuals. Indeed, what his lordship observes is that paragraph 50, that the only approaches that Mr. Stanley made, and he did realise that he ought to do something in relation to realising this cause of action, were to Cruden, which had been the petitioning creditor of the insolvency, and also Manolete. The most obvious people he left completely out of the equation. And that's why his lordship said, at paragraph 51, Mr. Collins submits that the liquidator's omission to canvass the market is closely analogous to the omission of the liquidator in Edengate. And then his lordship refers to the formidable test. Now we say that unless there are really quite exceptional circumstances, the failure to conduct a proper canvassing of the market is perverse per se. But it gets worse when you see the liquidator's entirely faulty reasoning at paragraph 20 of his witness statement, the criticisms of which, by me, his lordship accepted. But then his lordship goes on at where we say he was respectfully fell into error, paragraph 53. Whilst Mr. Stanley hasn't provided a satisfactory explanation for his omission to approach Mrs. Lock or other members of the family, he plainly considered that Mrs. Lock wouldn't have had sufficient funds to purchase or compromise the claim. He had little prospect of successfully negotiating with Mr. and Mrs. Forrest. Well, that is really quite at variance with what his lordship says at paragraph 49 of his judgment, where he accepts my criticism of his lordship's reasoning in relation to impecuniosity. And it also says nothing about the wealth or otherwise of Mr. and Mrs. Forrest. And he said, 54, consistently with this proposition, because the point of, which is the point about settlement, had Mr. Stanley sought to canvass or explore with Mr. and Mrs. Lock or Mr. and Mrs. Forrest the options that might otherwise have been available, there's nothing to indicate he would have done any better. Well, that's because he never did it. And it is not an answer to say, I've threatened proceedings, and therefore, because they haven't come up with a load of money, I can sell this to a litigation management company. I can sell this asset of the liquidation without canvassing the market, because a person, and Mrs. Lock is one of them, knows full well that claims which are properly arguable can be brought, which fail, and that even though you succeed at the end of the day, there is a considerable nuisance value to litigation and a considerable likelihood that you will not recover all of your costs, and that is worth something, and that is what people will pay for when making this evaluation on the shows in action. But we were never given that opportunity, and that's what the liquidator should have done in this case. In my submission, it is absolutely on all fours with Edengate.
Well, I mean, was the question for the liquidator whether there was a prospect that your client would make an offer, or was it whether there was a prospect that your client would make a better offer than the one which was on the table from Manolete, which included a reasonably substantial upfront payment, a share in the proceeds, and no costs worry?
Well, there wouldn't be a cost worry, of course, if the shows in action was just disposed of come what may, because that would certainly not to anybody, because that takes the whole cost. If the shows in action is disposed of, the cost issue goes entirely.
Yep.
And so far as the rest is concerned, the problem with it is the liquidator never even went down that route. I accept that if there is that in a circumstance, and perhaps not an exceptional circumstance like a freezer, but a circumstance would be that the liquidator does not believe that the person will buy the cause of action. Either they won't buy the cause of action, or they won't be able to afford to buy the cause of action. I mean, in which case one wonders why the cause of action is being assigned at all, so that somebody can pursue it against somebody impecunious. But that's not this case, because the impecuniosity point is very poor, and is not a good reason. But what it boils down to is, I'm not at the stage here of asking your ladyship and your lordships to adjudicate between two different offers. We're at an earlier stage than that, about process, about proper process, and there is nothing in this case which indicated that the liquidator should not follow the obvious process of testing the market, for which there is indistinguishable Court of Appeal authority.
So, in fact, Mr. Collins, sir, I dragged you forwards to the detail of the reasoning of the liquidator, etc. But you would say you don't need to look at any of that or what the judge said about it, because everyone fell at an earlier hurdle, which is it says what it says in Eden Notes, and you didn't do it. Full stop.
Yes.
That is really what you're saying.
But, milady, if I am dragged into it, it makes matters worse, because the liquidator's purported reasons just simply don't stand up at all. This is just ex post facto justification of an unjustifiable position in our submission. I mean, I think I've probably encapsulated all my submissions now, unless I can be any further assistance at this moment.
Thank you very much, Mr.
Thank you very
Collins.
much, milady.
Mr. Carr.
Yes, thank you, my lady. My lady, my lords, reduced to a sentence, our position on the first ground of appeal, namely the standing ground, is that simply being a creditor is not enough to have standing to apply. You also have to be acting in that capacity in order to have standing to be heard, as in any collective insolvency process. And what that means in practical terms is that in seeking the relief you seek, whatever it is, your interests have to be aligned with those of the collective interests of the class of which you're a member. And in my respectful submission, there's no novelty in this contention at all. It's a thread that runs through all collective insolvency processes, as I've endeavoured to set out in my skeleton argument. And what the more recent case law shows, including the Break Lows case, which my Lady Justice Asplin will be very familiar with, is that the court is always alert to scrutinise the real capacity in which people apply. And these cases are acutely fact sensitive, and there aren't any bright line rules. And one of the key divergences between my position and that of my learned friend is that my learned friend is preoccupied with what he describes as process, and the implication that there are some kind of bright line rules about the way a liquidator exercises his dispositive discretion in a case like this. I'll address at the outset, if I may, a point about the reasoning of the judge below that my learned friend made, which I respectfully submit wasn't entirely fair on the learned judge. And it was a point when granting permission to appeal. My learned friend submitted this morning that the learned judge took the view that that things had moved on since Eden Note, and that Eden Note had been overtaken by other authorities. In my submission, that isn't what was in the judge's mind at all in reaching his decision. If I could just show the court the transcript from what the judge said when granting permission to appeal, which is at page 85 of the court bundle. On page 85, the bottom left panel, which is page 18 from the transcript, the learned judge said at line 9 of page 18, "I think what is unusual about this, Mr. Curl, is the point that I have made to Mr. Collins, that effectively I have ended up distinguishing the Court of Appeal authority that being Eden Note. As you say, the authority since Eden Note has all gone the other way, as you've demonstrated. But as it stands, we do still have Eden Note, and it has not been overruled or reversed, and so ultimately I distinguished Eden Note in my judgment. Now, the learned judge didn't suggest that Eden Note was wrong or had been overtaken. It's simply that the facts of Eden Note weren't the facts that were before him in the case that is now before this court. And moreover, the point wasn't taken. The point that is being argued today wasn't taken in Eden Note. So there's, to be absolutely clear at the outset, there's no suggestion from the respondent that this court is asked to depart from Eden Note or say that Eden Note was wrong, per incuriam, or any of the rest of it. The case law is consistent on this point, and where the point has been taken, the court has scrutinised capacity very carefully. And the three cases that I rely on in particular are the Deloitte case, Walker Morris and Galaschi case, and Brake and Lowe's. My learned friend has said very little indeed about the latter two of those cases, which, in my respectful submission, my learned friend's outsider theory and process-driven approach simply can't deal with those authorities. Now, that line of cases make clear the following two propositions. Standing to apply under a statutory gateway, which Lord Millett referred to as the jurisdictional stage in the Deloitte case, and which we could alternatively call formal or nominal standing, that's only the first stage. The second part of the process is that the court has to scrutinise real capacity. And that's been put in a number of different ways. It's put by Lord Millett as having a legitimate interest in the relief sought. Another way of saying it, perhaps a more modern way of saying it, would be to say that the interests of the applicant have to be aligned with the collective interests of the insolvency. Now, the liquidator accepts, for the purposes of this application, although not more widely than that the appellant satisfies the first of those stages, the jurisdictional stage, i.e. she is within the category of any creditor, debtor or other person aggrieved, which is common ground between my learned friend and I, is the statutory threshold in section 168.5, although it's not spelt out there. Where the appellant falls down, though, is that she doesn't have a legitimate interest in the relief sought. Put another way, she's not acting in the interest of the creditors as a class, or put yet another way, her real capacity in which she applies is other than that of creditor. And the concept of dual capacity, on which my learned friend has put quite a lot of weight, that doesn't rescue the appellant's position either, because the evidence shows that the appellant is not acting in the capacity of creditor at all. In the cases where dual capacity has been referred to, primarily Eden Note, the dual capacity is that of creditor on the one hand and disappointed bidder on the other. And it's possible, depending on the facts, and these were the facts in Eden Note, that those two capacities may find themselves in alignment. But the dual capacity on which the appellant has to rely is the dual capacity of unsecured creditor and defendant to a good claim vested in the liquidation state. To all intents and purposes, that's a dual capacity of claimant and defendant in the same proceedings. And those capacities are irreconcilable. And as my Lord Justice Stuart-Smith already has touched on today, the reason that it's impossible for the appellant to be acting in aligned capacities, i.e. as a creditor as well, is because the class interest of the defendants is to minimise the amount of this claim. In other words, to minimise recoveries into the estate.
they're not necessarily irreconcilable, are they? I mean, suppose it was a straightforward cash bid by the litigation funder and no share in recoveries, and the target, whose interest was to kill off the claim, was prepared to pay a bit more.
The capacity of raising a complaint before the court would be irreconcilable, because the solution would simply be for the defendant to remake that offer.
Well,
and if it was...
Suppose he was never told about the assignment, but was able to prove that he would have offered a bit more if he'd known about it. What then?
It's not totally out of the question that there could be facts that would arise where there was good solid evidence that there was a superior claim, a superior offer, but it cannot be reconciled on the facts of this case because of the waterfall structure of the way the assignment was put together.
Oh, that's another thing, but you were making, I thought, a more general point that you could never be, you could never have standing if you're a defendant to a claim by virtue of happening to be an unsecured creditor.
That wasn't my intention to make an absolute point
Okay.
like that. What I intended to submit was that it's impossible for the appellant to be acting in the capacity of both claimant and defendant.
Can we just go back one step, just for my benefit? Is your position then this, that if a person's action is in alignment with the interest of the creditors, the fact that they may have a private additional motivation doesn't deprive them of standing?
The short answer is that's correct. It doesn't deprive them of standing. The slightly longer answer is that the fact that there was some other private motive might go to the weight to be attached to whatever that creditor said when it came before the court.
But if on the facts of this case the proper conclusion was that the Locks were trying or intending to put in a superior offer, the fact that they were doing it because they wanted to protect their parents-in-law from the traumas of litigation wouldn't prevent them from having standing.
No, there's nothing wrong with that at all.
No, nothing wrong. So that goes to your irreconcilability point, doesn't it? Because provided they're acting in a way which is in a creditor acting in a way which is in alignment with the interests of the creditors as a whole, the fact that they have some other motivation doesn't deprive them of standing.
It doesn't deprive them absolutely of standing if there is good, compelling evidence that the liquidator has missed out on a better deal.
Well, that was my premise.
Yes.
But they need not necessarily provide the best deal. They simply have to be acting with an intention that is in alignment with the interests of the creditors. So they have to be attempting, at the least, to overtop any other offers.
That as a proposition becomes, in my respectful submission, quite unreal quite quickly, because they have to, the amount they have to find is necessarily the same amount that they
But I'm doing
find.
it purely in abstract. I'm not looking at the facts of this case at all. If you've got people who are in an equivalent position to the Locks, if what they're trying, if the court is satisfied that what they're trying to do, or were trying to do, was a genuine attempt to overtop other offers, they would have standing to do that, that would give them standing, even if at the back of their minds they were thinking this litigation is a complete shocker and a nightmare and we've got to buy it off.
Yes. on what I would respectfully submit are the very, very unlikely assumed facts there, namely that a defendant is prepared to pay any amount in order to flatten any competing offer in the market, because they just have to kill it now. On those respectfully unlikely premises, the answer is yes.
But are you not? I'm sorry to interrupt. I'm sure my Lord Justice Stuart-Smith will say again what he wants to say. But are you not mixing up then perversity and the second limb of standing, in the sense that you're saying, they have to be people, therefore, who would pay anything to get rid of this in order to satisfy the second limb of standing, whereas I think what's being put to you, and what seems to me to be more likely, is that in order to satisfy that second element, what they're doing has to be aligned with the creditors as a whole. I can quite see that what you're saying, that in order for that to be the position, they've got to be attempting to overtop other offers, which is the way I think my Lord Justice Stuart-Smith put it. But it doesn't mean that they're, in order at least to jump that second hurdle, the second part of the standing hurdle, that they have to be willing to pay anything and to be able to prove that they would be able to pay anything. They just have to, in order that their interests align with those of the creditors as a whole, have to be attempting to overtop other offers. Would you accept that?
I would at a very, very high level of abstraction, but I would reiterate the submission I've made, which is that it becomes unreal very, very quickly, because such a party would in real life they would already have settled. They would already have responded to the letter before action and would have said, all right, let's do a deal here.
Well, my lady's encapsulated what I was trying to say much more clearly, but I'm not sure at the moment that I would accept that they would inevitably have settled, particularly when, whatever else you say, no claim against them has been intimated.
Of course, they haven't lost out on any opportunity to put forward the offer that they would always have put forward, and I think this was a point that your lordship addressed with my learned friend, Mr. Collins. Nothing has actually really changed, because they can still do what Mr. Sugar did in the Eden Note situation, which is, by the time the case had come to court, there was evidence before the court, which is recorded in the first instance judgment of Sir John Vinelop, where Mr. Sugar had said, right, I would have paid $75,000 for that, which was, although it was structured differently from Mr. Venable's offer, it was certainly competitive with Mr. Venable's offer, which was $7,000 up front and 10% of recoveries. And what the appellant in this case has signally failed to do is fortify her position by saying what she would have paid, and not only that, such evidence as does touch on the point seems to labour under a misapprehension about the waterfall nature of the Manolete assignment. So the exchanges that have taken place over the last few minutes to do with what I would submit are quite unlikely premises at quite a high level of abstraction do tend to fall away when one looks at the reality of the position, which is that these respondents are still responding to this claim, and they still have not made any proposal to compromise or settle it. And the value to the estate, there seems to be a misapprehension on the part of my learned friend, which is that there's a difference between the nuisance value of a claim and the merits-based value of the claim. And this point I was going to expand upon in a few minutes, which is that the preponderance of the cases where assignments from insolvent estates are in issue, they concern cases where the office holder doesn't think the case is very good, and the main enthusiast for bringing the claim is either the insolvent individual, the bankrupt, or the former directors of the company that's in the insolvency process. And those individuals think the claim is really good and it absolutely must be brought. The office holder doesn't think the claim is any good and they don't want to bring it. And that kind of case, of course, has a nuisance value to the defendant, because the defendant wants to be able to get the insolvent individual or the former director off their back, and they want to get an assignment ahead of the insolvent individual or the former director. And that's where all this talk about nuisance comes from. And the authorities in the bundle, Faryab and Smith and Official Receiver and Hamilton are that kind of factual matrix. And Eden Note probably is as well. This case is in a very, very different category, because this case is a good claim, and the liquidator wants to pursue it for the benefit of the estate. It's essentially the only game in town, because there are literally no other assets in this estate. The only way recoveries are going to be made into this estate is from the appellant and the other respondents. And that will either be by way of compromise of this claim, by them paying money in compromise of the claim, or it will be by way of pursuing it to trial and then making contested recoveries from them. So to the extent my learned friend talks about...
Or pursuing it to trial and failing and simply walking away with the 30,000.
Yes. Is the short answer, my lord, yes.
Yeah,
So that's litigation risk, and of course one would attribute a value to that if...
Well, I only say that because you say it's a good claim, the Lock say it's a bad claim, and we're not in a position to form any view about that.
No, well, absolutely right. That's in the nature of any contested insolvency litigation, or indeed any litigation at all. And if one were dealing with the Locks to try and compromise the claim, I'm sure I'm not giving anything away when I speculate that Manolete would probably attach a value to early settlement. That's just in the nature of any kind of negotiation over settling a claim. It's just in the nature of things. But the point I'm endeavouring to make is that it's not... There isn't some difference between a nuisance value, which you can get as a person in the position of the appellant by way of an assignment, and the actual merits-based commercial value of the claim, with or without a discount for early settlement and the risks inherent in litigation. The value of the claim for settlement purposes in the hands of the liquidator or in the hands of Manolete, as against the appellant and the other respondents, is the same. It doesn't have a special nuisance value. So to go back to the point I made a few moments ago, the appellant hasn't lost anything, because she can still settle these claims, compromise them. I dare say Manolete, if it's particularly important to the appellant to take an assignment of the claims from Manolete, I dare say Manolete would compromise by way of assignment. But the value of the claim is the value of the claim, and not only has...
whether she puts it up as a price of buying the cause of action, or whether she puts it up as a settlement figure to Manolete or whoever it may be. Is
yes,
your point?
It's the same. That is my point. Yes,
yep.
This isn't a claim that I'm sure the court has seen Miss Lock's second witness statement, where she talks about. I'm sure we'd have been able to come up with more than 30,000 or words to that effect. Apparently, under the misapprehension that that's the value of the Manolete deal. But nothing's been done to fortify that. There's no recognition that the value of the claim, the arithmetic is something like the claim is 1.2 million. applying very, very conservative interest to the date of assignment only, and of course it's somewhat more than that now, applying conservative interest of 3%, that gets you to fractionally under 1.35 million. And so allowing £100,000 for costs, the arithmetic, on my arithmetic, that comes to £839,000 for the estate. So that's the value if it goes to trial, fights and wins. So that is the starting point for negotiations.
But that's after taking out Manilo's cut.
Oh yes, it's after taking out taking out Manolete's cut. But if it's absolutely it's simply fanciful for the appellant to submit to this court and the court below that she's actuated by maximising recoveries for the estate when she says there's no claim, it has a nuisance value, and she attributes £30,000 or so to it. It's just not. It's just not a serious application in my
But
perspective.
is your point that, as things stand, the evidence is that this case could not settle, and we should infer from that that she could not overtop the Manolo bid?
In a nutshell,
I
my
can't
lord,
pronounce
yes.
the name properly, but I hope that everybody will forgive me when I get their names wrong.
Yes, is the short answer.
That's the inference you want us to draw.
Yes, it's more than an inference, my lord. It is the effect of the evidence, because there's not a trial here. We're going on the witness statements, and the evidence that Miss Lock has put forward, Mrs. Lock has put forward, is equivocal at best, and to the extent she plumps for a figure, it's around the £30,000 mark. We're just that's a million miles away from the sort of numbers that we're really talking about.
Well, I suppose we can take it that the Manolete view, right or wrong, is that the claim is worth much more than £30,000, otherwise they wouldn't bother to pursue it.
That's right.
Although there's also Mr. Collins's point that they're pursuing it against people who, on one view, have said they haven't got any money.
Well, there's a distinction there to be drawn between the position of the appellant and the position of her parents. The liquidator didn't invite assignment with the appellant because the appellant had said on the liquidator's evidence that she was impecunious. There's the parents are a different story.
Because of the 21st of May letter.
I meant in terms of recoveries, my lord.
Yeah, but also in terms of offering them the opportunity to come in.
And they were offered the opportunity. Yes, my lord. That's right.
But all of this, Mr. Clark, goes, you say, do you, to the second limb of standing, i.e. whether in reality they were would be able to attempt to overtop the offer, and also to perversity, because you say, in reality, on the facts here, the liquidator was right to do what he did.
The short answer, my
Or
lord,
not
is
wrong
yes.
to do what he did.
Yeah.
Or
The
not
sh-
sufficiently wrong to do what he did.
It wasn't perverse.
Mm-hmm.
And yes, my lady is absolutely right. The submissions over the last few minutes have tended to sort of jump about a little bit from the second stage of standing to the concept of perversity. But I am very clear in my submissions that the judge was right below to find that Mrs. Lock didn't have standing on the basis of the second element of the Deloitte and Johnson approach, namely that her interests in which she was acting were not aligned with the class of which she was a member, namely the unsecured creditors.
On the facts of this case, but not just because she was a potential target.
Precisely so. Yes, that's exactly right. Yes. Now, perhaps I can show the court the Walker Morris and Colaci case, which is particularly apt for the facts of this situation, and that's at Authorities Bundle tab 8. Now, this case, what I respectfully submit is the gist of this case, is that simply being a creditor is not enough for the purposes of Section 1685. You have to be acting in that capacity as well. And in my submission, this case presents an insurmountable barrier for the appellant's position today. Now, it was accepted in that case that the applicant was a creditor, just as it's accepted today that the appellant is a creditor, and so accordingly they were through the jurisdictional gateway without any difficulty. Now, my learned friend seeks to explain this case on the basis of his outsider theory, and he also qualifies the creditor's position on the basis that the claim was minuscule, £237. And my learned friend says that the minuscule nature of the claim meant they were effectively an outsider. Now, in my respectful submission, that's not how this case was reasoned, and it's not how it should be interpreted today. The way the case was reasoned was that the applicants weren't proper people to invoke the court's jurisdiction to control the liquidation because of their real capacity. It wasn't on the basis that they were an outsider.
It's there at the top of page 96 at A, isn't it? In my view, the situation in this case is in substance the same. It's true that the applicants are creditors and would have locker standi if acting as such, but this is irrelevant since they are in fact seeking to advance the interests of possible debtors which are adverse to those of the creditors.
Precisely so. Your ladyship has made my submission for me, so I can now move on.
Sorry.
No, not at all, my lady. That is the point.
And that is precisely the passage which is, perhaps not surprisingly, cited in Broken Letters.
Yes, quite so, my lord. Yes. Before departing from this case, I would I simply like to make one further observation about this case, which is that the appellant has suggested that in having a creditor claim for just £237, the creditor in Walker Morris didn't have a serious interest in the capacity of creditor. But that poses a significant difficulty for the appellant because, firstly, as soon as one recognises that formal standing as a creditor is qualified by economic reality, then there's no rational stopping off point between that position and the position that I adopt, which is simply that the court does look at economic reality. Applying that sort of reasoning to this case, the appellant has an even smaller interest qua creditor than did the creditor in Walker Morris, and that's because the appellant has to pay in more to this estate than she stands to receive by way of a distribution. And so her net interest isn't even £237.
That's on the basis that the claim is good, etc.
Yes.
Have I understood this correctly? She has to pay more to get than what she would get by way of dividend if that goes into the pot.
Yes.
Because of Cruden's 2 million.
Yes. Yes. In fact, my lady, if I could just qualify that slightly, she, unless recoveries are made from her and her family, she won't get any distribution at all, because there isn't going to be a distribution unless recoveries are made from these respondents by means of this claim. So this is a very well, it's not an unusual insolvency. It's a usual insolvency, but it is out of alignment with some of the cases on which my learned friend relies. So Edennote being the obvious one. Edennote, there were other assets. Mr. Venables was on the receiving end of what looked like an unanswerable preference claim. And there was every reason for the creditors in Edengate to want to stop Mr. Venables bringing his proceedings against the sugar interests so that he didn't squander his money, because he was already impecunious, and that was recorded in the judgment. So he didn't spend all his money suing Mr. Sugar, so that he couldn't then answer the preference claim to enable recoveries to be made back into the estate. So it was there were more moving parts in Edengate that simply don't arise in this case, where it's a single asset case, i.e. the claim. There's no wider context of litigation involving third parties, which means it might have a nuisance value to some or other of those third parties, which was the factual matrix in both Edengate and in Ultrafame and Rigby. It's straightforward bilateral litigation with one set of respondents. The cause of action has no value other than to make recoveries in respect of that cause of action or settle it. And the respondents are not going to receive a distribution, and nor is anybody else, unless recoveries are made from the same respondents. And so the greatest respect to my learned friend, his reasoning does rather collapse in on itself, because these individuals have got a creditor status, but only in respect of claims against themselves. And it is very difficult to see how that is a serious capacity of creditor that can grandstanding to come along and complain about a liquidator who in good faith has tried to make recoveries for the estate.
Well, we go back to the point that we discussed earlier, which is if they could demonstrate that for whatever reason they were prepared to overtop and in a position to overtop any other bids, the fact that their reasons might be weird and wonderful, or the reason that you've just given, wouldn't prevent them from having standing.
It wouldn't, but it would be a very curious set of facts where someone appears before the court relying on that kind of argument to grandstanding, but is simultaneously saying the claim has no merit and I'm not prepared to settle it, which is Mrs. Locke's evidence before this court.
It doesn't strike me as being particularly unusual for litigants to be saying one thing at one moment and asserting that the claim against them has got no value at all at another. That seems to me to be relatively normal.
It's amazing how many of those claims do settle.
It is a remarkable state of affairs for someone to be challenging the assignment on the basis that they might have offered more, while simultaneously putting in the evidence that they, by their silence, that effectively they don't have an offer to make for that cause of action. I mean, my learned friend frankly admitted that this is all process. This is a process argument. So the respondent is complaining in the capacity of creditor, she says, who by that token must want to make a recovery, but she wants to make a recovery from herself, having not made an offer, and doesn't propose to make one until the process is got right, which is in my respectful submission, it's completely unreal.
Okay, so I think we have your submissions in relation to standing, the two elements of standing.
Yes.
What else would you like to say about perversity?
Well, there was one other case I did want to take the court to, which was the Break and Lows case on the second stage of standing, which I know, for obvious reasons, my lady, I can take extremely briefly. So if I might just draw out a couple of points, which I think we're in danger of getting lost in my learned friend's submissions. The appellant's position in a nutshell is that the position today is indistinguishable from the position of the unsecured creditors as they were defined with a capital U and a capital C in Break and Lows. The doctrinal points I would like to draw out of this case are, firstly, at paragraph 83, your ladyship found that there's no need for interests to be positively adverse in order for standing to be precluded. Now, my learned friend, I thought, came close during his submissions to suggesting that if not that they did, that was the factual matrix in every decided case. But we've got clear Court of Appeal authority at paragraph 83 that the interests don't have to be positively adverse. Although in my submission, as it happens, the appellant's interests on the facts of this case are positively adverse to the estate.
But this is in relation to section 303, isn't it?
The court also found that the test is the same. So if I could just turn that up. This was during the discussion of the breaks in their capacity as former bankrupts. That is right, but there is a passage.
Thinking of paragraph 88, line 4.
Yep.
Where my lady says all the matter. I mean, if I'm right, it's a fluke. I just happened to alight upon it.
That isn't the paragraph that I was thinking of. I'll find it over the short adjournment and come back to it if I need to. But the fact that the liquidation appeal was disposed of in one paragraph on the basis that it was essentially piggybacking on the reasoning in the bankruptcy appeal provides the answer. I would respectfully submit, but there is a paragraph. I'm quite sure there's a paragraph where it says the test is the same. But I'll come back to that. So that was the doctrinal point that I wanted to draw out of this case, and I would also just like to draw the court's attention to paragraph 103. Which is at page 341 of the electronic bundle. And my Lady Justice Asplin records there, in this case it seems to me that even if the unsecured creditor's application is not adverse to the liquidation and might increase the sums available to unsecured creditors, the judge was entitled to adopt the same approach as Nicholas Strauss, Queen's Counsel, that being the Walker-Morris case. Although they are creditors, it seems to me that the judge is right to take account of the unchallenged evidence to the effect that the unsecured creditors were seeking to advance the interests of the bankrupts rather than their own. Theirs was not a dual capacity because they only sought to advance the breaks case. In my submission, the position of the appellant is even less promising than was that of the unsecured creditors in break and loans, in that she is, on her own evidence, seeking to advance private interests in her capacity as defendant and not as creditor. The unsecured creditors in break and loans had at least made an attempt to put together a sort of creditor-friendly presentation, shall we say, although it was possibly quite thin. But they had at least attempted to tick that box, if I might put it like that. Whereas the appellant in this case simply hasn't addressed the creditor interest at all, and one searches in vain in both her witness statements for any discussion of the creditor interest or anything that might touch upon it. So moving on now to perversity. Reduced to a sentence, my client's position is that the judge was right to find that the decision here was not perverse on the hypothesis that the first ground of appeal succeeds. The parties are essentially agreed on the test. I cover it in some detail at paragraphs 11 to 18 in my skeleton argument, which I won't repeat, but it's commercial judgment, business person's decision. The office holder is not to be second guessed, essentially. Now, in my submission, an office holder is entitled to the court's support in their decision making unless they have gone badly off the rails. And that the other side of that particular coin, or the trade-off for that, is to avoid the situation where office holders are running off to court every 5 minutes to seek directions, is that they make their decisions in good faith for the right reasons and are entitled to have those decisions upheld unless they are perverse. Given the height of the hurdle, namely perversity, there must necessarily be a very wide category of cases, and perhaps it is most cases or even all cases, where an appellate court, sometime after the event, reviewing everything, scrutinising it very carefully, having it pressure tested by leading counsel for a dissentient party, might be able to identify one or two points where things might have been done differently. The fact that something falls into that wide category doesn't begin to answer the test of perversity. And the judge below was quite right to distinguish between the situation as he found it to be, namely that the liquidator's explanation for his decision-making was unsatisfactory, and the high threshold of perversity. And the judge, although the judge did criticise, as my learned friend took the court to earlier this morning, did criticise one or two features of the liquidator's explanation. He didn't say the decision-making was wrong, he didn't say the decision itself was wrong, and crucially, he didn't find the test of perversity satisfied. To that, I would add that this court is being asked to revisit an evaluative judgment reached by a judge at first instance after hearing full submissions and considering all the evidence. And this court should also accord a margin of appreciation to the decision of the first instance judge, even if your lordships and my lady wouldn't necessarily have come to the same conclusion. Now, if I could just revisit the way the vice of the situation was identified in Eden Note, if I could invite the court to turn to page 31 of the authorities bundle. At the foot of the page, that said, it is certainly possible for a liquidator to do something so utterly unreasonable and absurd that no reasonable man would have done it, simply by selling an asset of the company without taking into account the possibility that a third party might well have made a better offer than he to whom it was sold. There's two features of that that aren't apt for the current situation. In Eden Note, the liquidator didn't consider the possibility of an assignment to the sugar parties because he thought it would have been improper to have done so. And I've set the references out where several references to that are made in the judgment at first instance of Sir John Vinelock. Now that truly was a perverse decision because it was wrong and the liquidator had misdirected himself on the law. Doesn't arise in this case because the liquidator wasn't under any such misapprehension or misdirection, and indeed at paragraph 20 of his second witness statement and the passage that's set out in the judgment below, the liquidator explains why he took the approach he did, and it's not based on any misapprehension of law or misdirection. The decision reached in good faith, and it's well within the bounds of the sort of decisions that a liquidator might come to. The second feature of the passage that I just read out from the Court of Appeal's decision in Eden Note is that in this case, there was no possibility that Miss Lock would have made a better offer, because we have the evidence of the offer that she contemplates that she may have made, namely that they might have been able to raise a bit more than £30,000. And we know that wouldn't have been a better offer. And although it's often said in these cases about reviewing discretionary judgments that a reviewing court shouldn't apply hindsight, but this is an unusual case where one can see by the application of hindsight that the liquidator's decision making was actually spot on, because Mrs. Lock has put in 2 witness statements since the liquidator reached his decision, and has not taken the opportunity to set out what a competing competitive offer would have been. So
is that really a point that arises out of the fact that Section 1685 gives the court a discretion, and there's no point in exercising that discretion, even if there are flaws in the liquidator's reasoning, or perhaps even if the liquidator's conduct was perverse, if it is crystal clear that no better offer is forthcoming?
Well, my lord, the court should only interfere if the decision is perverse. But even if there are shortcomings, the court should not interfere unless it is perverse. So the threshold is perversity, and nothing less than perversity will do. But I suppose that your lordship's observation is correct in that even if the reasoning does meet the test of perversity, if subsequent events have shown that there is absolutely no point in reviewing the decision because hindsight has demonstrated it to have been correct, even if at the time it was made, it was reached in a perverse way based on a misdirection, then my lord's suggestion is quite right.
I'm not sure it was ever put like that, and of course you say it doesn't arise on the judge's findings.
No, it certainly isn't put like that, my lord, because we say we say no standing, and even if there is standing, it certainly wasn't perverse. It was a very good decision. But what I'm making the observation now that if one applies hindsight, which normally office holders are reluctant to see applied, because normally the reason someone's made a complaint is because hindsight has shown that there was something the matter with the decision, or that it would have been reached differently with the benefit of hindsight. But in this case, with the benefit of hindsight, the decision would have been exactly the same, because Mrs. Lock is saying I might have been able to produce a bit more than £30,000 between ourselves, and we're the liquidation estate stands to get more than £800,000 if it goes all the way.
And that's sort of encapsulated at paragraph 54 of the judgment, where the judge says there's nothing to indicate that that the liquidator would have achieved better terms, whereas in Eden Note there was evidence of the 75,000.
Precisely so, my lady. Yes, that's right. I mean, considering the judgment is only 10 or 12 pages long, it's remarkably rich and accurate, I would respectfully submit. And considering it was turned around in a space of less than a week, it's a very good, if by respectful submission, a very good distillation of what how the law actually stands, following break and lows.
Going back to my Lord's point, sorry to be so slow, but on the exercise of discretion, I suppose the question that my Lord poses could arise in 2 circumstances. One, if we were satisfied that the appellant is right, that there was a failure of process, or 2, if we thought that the liquidator's reasoning, as he explained it, was just wrong on the information he had at the time. And then I think the point would arise that you would say there's no point in the court interfering if it couldn't affect the ultimate outcome. And you would say that because it's now completely clear that they would never have overtopped we shouldn't interfere?
Again, the short answer, my lord, is yes. I would take respectfully very slight issue with your use, your lordship's use of the word wrong. Simply being wrong in the views of an appellate court, even on the basis of the information he had at the time, would not be sufficient. I would submit it must be perverse. Yes.
Yes, I take the mark. Yeah.
I suppose if we did set the assignment aside on the basis that there was a failure of process which made it perverse, and that there now needed to be an opportunity for other parties to bid, that would be in a sense adverse to the interests of creditors, because it would put the claim at any rate into some kind of abeyance until the bidding process had been completed, because the liquidator's got no funds to pursue it on his own. Manolete would be off the scene unless they made a second successful bid, and we wouldn't know whether that was going to be beaten by the Locks or anybody else who might come in.
My lord, that's quite right, and that shows the great difficulty in making recoveries from estates that are entirely insolvent without the assistance of litigation funders, and that's why these sorts of assignments take place, because otherwise it's all too easy for respondents to put their company into CVL, because that's what Mrs. Lock did before Crudden got the compulsory winding up order, and avoid liability that way. The whole process would be enormously adverse to the interests of the unsecured creditors as a body. This whole process already has been hugely adverse to the unsecured creditors as a body. This matter was supposed to come on for trial a few weeks after this application was heard, and this application, that's why, in fact, Judge Halliwell below turned his judgment around in less than a week, was to enable that trial to be effective. And this appeal has required that trial to be stayed to abide the outcome of this appeal. So it's already been enormously adverse.
So has all the disclosure happened and all the witness statements have been served and so on, so the trial is, or was, literally ready to go?
I'm not instructed in those proceedings, but my understanding is that the trial was absolutely ready to go. A very experienced insolvency counsel was briefed for that trial, yes, the trial was going to happen in December, a few weeks after Judge Halliwell handed his decision down. So there's already...
So as easy as it is ever going to be for people to form their views of what the claim is worth, because all the evidence subject to cross-examination, etc.,
yes,
is on the table.
Absolutely, my lord. Yes.
I appreciated that.
Yes. Now, the claim has a merits-based value that is very significantly more, many times more than the sort of negligible or nuisance token value that this application to set aside the assignment seems to be premised on it having.
So you say?
Yes.
So.
As to perversity, the focus of the appellant's witness statements is on the claim being a bad claim, on the personal injustice that she feels in being pursued at all, and the sense of grievance that she feels in the petitioning creditor having conducted themselves in the way that they did and in having petitioned for compulsory winding up. There's no real discussion of creditor interests at all, and I would just like to remind the court of what was said by Mr. Justice Lightman at the conclusion of Eden Note number 2.
Is this the passage you cited in your statement?
And this is, I'm afraid, my lord, I can't remember whether it is or not. And it's the passage at page 95 of the report, which is page 62 of the bundle. Oh, in fact, it starts on the previous page, page 61. And his lordship says, I should conclude by saying that Mr. Venables has in this case misconceived the nature of the jurisdiction of the court. I am concerned with what is in the best interests of the company. Arguments to me addressed as to the prejudice to him as a prospective purchaser are nothing to the point, and to that can be added to Mrs. Lock as a defendant are nothing to the point. The question is the commercial best interests of the company, reflected prima facie by the commercial judgment of the liquidator, a judgment in my view which in the circumstances and in the light of the evidence in this case ought to be given full weight. That's entirely apt for this case in my submission. The only consideration for this court is the interests of the creditors, just as that was the only consideration for the liquidator in exercising his discretionary power to assign this claim. Now, unless there's anything further with which I assist the court today, those are my submissions.
No, thank you very much indeed, Mr. Gull. Mr. Collins.
Yes, thank you, my lady. The reference to the third round of Eden Note is interesting because, but one has to bear in mind that that was in fact an application by the liquidator for directions, because once he had been told that he had not followed a proper process in realising the best price for the asset being the shows in action that Eden Note had, he took a rather more careful course. He conducted a bids procedure, which ultimately T PLC and T Limited won. That is on page 59 at B. And that's important for a reason I'll come back to. And then the liquidator applied for directions by way of a belt and braces because of the terrible kerfuffle that he'd got into in the past. But that's useful because the only way in which this whole process benefited the liquidation was by TPLC buying the cause of action for more than somebody else once a proper process had been pursued, and that in no way stripped it of its locus standi as an unsecured creditor. And Manolete Friend talks about an air of unreality, but there is something of an air of unreality in relation to his submissions when he goes on about creditors. Could I ask you to turn up, please, page 62 of the supplemental bundle? And to look at the statement of affairs there submitted by one of the then liquidators. And to turn to page 68 of the statement of affairs and to consider two entries. One is Adele Lock, which is just below the first punch, which is £2 million. And just above it is a company called Affordable and Stylish Limited, which is Mr. and Mrs. Forrest's company. And between them, they account for nearly 2.2 million out of 2.5 million of the creditors. And so we're talking about, nearly 90%. And in these circumstances, they're acutely interested in this insolvency. And when it's said that the value of the claim is the value of the claim, it is surprising, at the very least, that you have that Manolete Friend says that it's a much better thing for there to be a great money go round, whereby Mrs. Lock and her parents are sued by this highly commercial organisation. A load of money flies off into its pockets on the way round, and then £839,000 comes back to the estate, which mostly goes back to them.
Can you just remind me, this is the statement of affairs signed by Mrs. Lock?
Yes.
Which has Cruden in at whatever it is, 158,000. But am I not right in thinking they've proved for something over 2.5 million?
They've sought to. and there is a significant dispute over that.
Well, there may be a significant dispute, but what we can't do is take this as the ultimate
Very good.
exposition.
In which
My
case,
lord, page 15 of the supplemental bundle sets out the figures, and I should add that Mrs. Lock's status as a creditor is also contested.
Yep.
well, it's accepted here, but what we want to let us at the very least compare Mrs. Lock's position and her parents' position to that of Walker Morris, which had a debt of £237 and an insolvency of £144,000. We're in a completely different realm here in relation to interest in the liquidation. And Mrs. Lock, in her evidence, has been acutely interested in this liquidation. She sought to be on the creditors' committee. She's keenly interested in all of this. And it is not the case that her offer in relation to this estate is in relation to this claim is a mere £30,000. Her first witness statement makes quite clear that there's a considerable value to it all. And yes, of course, she stresses that these proceedings are very difficult and very expensive. But that's why they're worth money. And that's why they're worth money to any target of proceedings. And that's why they're obviously in the market, and that's why they should be offered to them. And that's precisely what Lord Justice North says. And so, and when she deals with the £30,000, she's talking about, plainly in my submission, about the initial payment on behalf of Manolete. It's not been ignored that there's a possible return in relation to this litigation, which we say is speculative. But we also say that a bird in the hand may well be worth a lot more than a bird in the bush. And of course, none of this addresses the position of her parents, who are also targets of this litigation, who should have been approached. And so, I do stress again
But
that
you
this
certainly don't have standing.
well, their company does. In fact, Affordable and Stylish would, and that's a creditor, and that's not actually a defendant to the litigation. Another of their companies is. So I suppose the better application might have been made by them, or we wouldn't have got into all this kerfuffle about lockers. Not that it's a good point. I'll come back to that in just a moment. But in relation to in relation to the process point, this isn't. I'm not just trying to run make a theoretical point here. This isn't a complaint about the conduct of a bid process. There was a case about that, which my Lady Justice Asplin addressed in Brake, which was the Hellard case, a case of Mr. Justice Sales, where the actual bid process was faulty and was set aside on precisely this jurisdiction. This is a complaint about there having been absolutely no process at all, and it's exactly like, therefore, Edengate. Now, my learned friend says, "Oh gosh, the liquidator in Edengate was really perverse because he didn't think he should invite an offer except from Mr. Venables." But and then my learned friend goes on to say, "But of course, you look at paragraph 20 of his witness statement, and that's the reasoning we adopted." Well, that is every bit as woeful as the liquidator in Edengate. And in fact, and as I say, I agree with my lady when it was suggested that it's prima facie perverse not to go through a proper process unless there's very good reason not to do so. And it's a fortiori in this case, because the reasoning that the liquidator has given for not having gone through the process, even though he offered it to other people, he didn't offer it to the obvious people, does him no favours either, because that's all completely perverse, as the learned judge found. The learned judge then effectively made up the reasons for the liquidator, speculated as to the reasons, but the reasons he gave in paragraph 20, the learned judge quite rightly agreed with all my criticisms, which are good. So that does not help in my submission at all. If this case is unreal, according as my learned friend says, so is he. Mrs. Lock's interests are not adverse to the estate, because what the interest is the purchase, is the sale of an asset in the estate, which is a shows in action. And my learned friend might look to the great bright sunny uplands of our £839,000, but that's not the point. The liquidator has to, in selling an asset, take a view at that time, and he has to evaluate the prospect of receiving £839,000 from this litigation, romping to victory, with a large amount of it going off to this highly commercial organisation, Manolete, against a bird in the hand of somebody purchasing the litigation, whereupon it doesn't actually proceed, and somebody who's significantly interested in the estate doing so, and he has to weigh that up. But of course, he never got anywhere near that because he just didn't do it. He just did not follow a proper process at all. And so we can't start, in my submission, guessing what the process might be, or this or that or the other. There's got to be a proper process in relation to all of this. My learned friend talks about public interest. The public interest in this case is ensuring that liquidators do their job properly and actually go about the process clearly set out in relation to these sorts of assets, clearly set out in Edengate and applied subsequently, that markets should be tested. And that's just simply not what happened in this case.
And so, Mr. Collins, you're reiterating, I think, that this is an issue, a question of there having been no process, and accordingly that must be perverse, if you like. What do you say, though, therefore, about the formulation that we were trying to test a little earlier about standing, which was A, you're a creditor, but B, you might also be the target of the litigation, but you would still have standing if you were attempting to overtop other offers. I see a difficulty there, given that you say nobody was ever in the position to do that at all.
Well, quite. And if you, and that's why one goes back to the sort of to the first stage of there not being any process, any proper process at all, because then one just speculates about what might have happened if there had been a process. But there actually needs to be the process, which was ultimately the process which was conducted in Edengate and blessed by Mr. Justice Lightman in the third iteration of Edengate, which was that TPLC, the creditor, actually bought the cause of action in the QB, which Edengate had, for a greater sum than Mr. Venables, of which it would then have got a portion back as having been a creditor, because it paid into the estate for which it was a creditor, and it still had locus standi in relation to doing that. The learned friend asserts about what our real capacity is, and we're not acting as a creditor at all. But that's just simply not right. We're in the dual capacity referred to by Lord Justice North and also referred to by Lady Justice Arden in the Ultraframe case, and as both a creditor and as the target, and it would be the same in relation to any asset. Let us say that a creditor of a company has a particular affinity for an asset of the company. I don't know, a company car or chattel or property or something like this. The liquidator sells sells the asset in an absolutely hopeless way, and obtains a ludicrously low valuation for it, a price for it. And this person had indicated his interest as a creditor. Now, of course, why should he not be able to complain that the liquidator has not fulfilled his duty and not set aside that transaction for not having followed the process? The only reason that my learned friend would say is because he was interested in buying the chattel for more money.
Your difficulty with that is that there is absolutely no evidence to suggest that this cause of action has been sold at an undervalue. Quite the contrary. He's tested every aspect of the market other than your clients, and has come up with figures which, as I read his witness statement, are quite compelling evidence that he did not sell at an undervalue.
Well, my lord, I must take issue with that, because when you say that he's tested every part of the aspect except my clients, and for that matter, Mr. and Mrs. Forrest, that's the main mark.
Where is your case? Where is your
market.
case that this has been sold at an undervalue?
Well, that wasn't the case in Edengate either.
That's not an answer to my question.
Well, Well, it is, actually, I would respectfully suggest, because in Edenote, there wasn't a balance between, we weren't adjudicating on competing
No, I'm
bids.
sorry, you're explaining why I shouldn't have asked the question, but I have asked the question. Where is your case about that this has been sold at an undervalue?
Well, I don't have a case that has been sold at an undervalue, but neither was there one in Edenote, except ultimately when the due process was followed, it had been sold at an undervalue.
I'm not going to engage in an argument, but I think you're neglecting the fact that there was evidence that the other interests would pay £75,000.
Well, in fact, they ultimately paid more than that, and there's evidence in this case that we would have paid a reasonable amount in order to get rid of this, but we were never given the opportunity. That's the point. And ultimately, in Edenote, it didn't matter. It was what was said at the bottom of Edenote on perversity on 394 was selling an asset of the company without taking into account the possibility a third party might well have made a better offer for it. And that's what Lord Justice North says at the bottom of 394 of the report, page 31 of the bundle. And he's not dealing with competing assets or something like this. It really is a question of process in Edenote, in our respectful submission.
You've just said, to my lord, that there is evidence in this case that we would have paid a reasonable amount. I think his question to you, and in any event one to which I would like to know the answer, is can you just direct us to that evidence so that we can see exactly what it says?
Yes. In Mrs. Lock's first witness statement, at paragraph 29, she deals with this on page 12 of the supplementary bundle. She explains about why they would be involved, because she's actually knowledgeable about litigation in which she's even been successful. An outright purchase by us for a reasonable sum, and as I wish to express, there's a considerable value to us of putting this whole matter behind us and concluding, could well be better than the speculative prospect of the liquidator receiving something or nothing from the long litigation process. And she stresses elsewhere, of course, that it's not only her, it's her parents that ought to have been included in this proper marketing of this particular asset, because the asset is a claim not only against Mr. and Mrs. Lock, but also against Mr. and Mrs. Forrest. And I mean, there just simply was no process followed in relation to that whatsoever. And the most obvious part, the most obvious market, was just simply not even embarked upon, let alone tested. And then when the liquidator tries to justify that in paragraph 20 of his witness statement, all his reasoning is completely faulty.
So that's at a stage when she doesn't know what the Manolete offer is, because she says it's been redacted, and then we have paragraph 81 of her second statement. Yes.
Yes. And
page 47.
Yes.
And that's what the evidence is it?
And yes. And what I would respectfully say there is she is concentrating on the £30,000 upfront payment. It's not being completely ignored that there is the hope value in the litigation as well, which becomes much more speculative, I accept. But of course, and then of course she refers to the point about her parents as well. And the plain fact is that one has to, just as ultimately happened correctly in Edenote, one has a proper process in which bids are invited. And ultimately, that's what occurred in Edenote, as we see from the third iteration of it. My learned friend referred to the learned judge's judgment on permission to appeal. Could I just highlight two other relevant references in relation to that? The first is His Lordship's N 460 form, which is on page 79 of the core bundle. I appreciate that there may be something of a debate about the status of an N 460, because in the olden days one just had a permission to appeal or not. But now one is invited indeed really required to produce reasons, and so they can illuminate. And what his lordship said in granting permission to appeal, that in reaching my conclusion I distinguished the Court of Appeal in Edengate, and in my submission that's quite right, he did have to do that. On the issue of standing and perversity, and I did so consistently with more recent authorities, but Edengate remains good law. And perhaps more satisfactorily, one looks at the judgment in relation to standing, and that is at page 69 of the court binder, paragraph 31. And this is where, as I said, my learned friend outgunned and dazzled, because his lordship says, however, having referred to Edengate, it has since been established that where in a case such as this an applicant asks the court and so on and so forth, and it's not since at all, because Edengate makes it perfectly clear that an outsider to the liquidation cannot make an application under this, and you have to have a sufficient interest as an unsecured creditor, and that, of course, in Edengate, there was the judgment of Lord Justice Norse was agreed to by Lord Justice Millett. He gave the opinion of the board in Deloitte and Touche, in which Edengate and the Court of Appeal was cited, as one can see from the weekly law report. When one then comes on to the other authorities, including, of course, Ultraframe and Brake and Lowe's, they all apply Edengate, and in particular refer to the dual capacity. And that's exactly what my client has. She has a dual capacity. She has a capacity as a substantial creditor in this liquidation, and she has a capacity as being very interested in a claim being brought against her. But that latter capacity is precisely what makes her in the market for this claim, and why that market should have been canvassed. So we would say that private motive does not agree with the learned friend that private motive cannot necessarily deprive you of standing. Indeed, it's what gives rise to this whole market. My lady and my lords, I think those are the only points which I would wish to elaborate in reply, unless there's anything further which can be assistance.
Thank you very much indeed, Mr. Collins. No, there's nothing further.
May I just provide the reference that I promised to provide after the
Oh, that's very helpful. Thank you.
It's paragraph 79 of Brake and Lowe's on page 337 that the principles in Deloitte apply both to sections 303 and 168.5.
Thank you very much indeed.
Sorry, would you just say that again? The paragraph?
Yes, it's paragraph 79.
79.
On page 337, the authorities.
Thank you very much.
I hadn't realised that my timing was quite impeccable. We're very much obliged to you, lady, and to your lordships.
Thank you very much, Mr. Collins. We obviously will reserve our judgments. You're all both very familiar with the way in which these things happen. We will send out our drafts for correction only, not for re-argument in any way. And then in the end, the judgments will be handed down, I think, electronically, and you're also aware that, of course, we'll ask you to try to agree an order, and if you can't agree an order, you should make short submissions on paper to assist us. I should also add that, of course, you'll be aware that when the draft goes out, it is subject to an embargo and should be dealt with very carefully, and should be sent to a restricted number of people, and you'll fully understand what I'm referring to in relation to that. I'm just flagging that up because that has become a very hot topic,
yes,
as you will appreciate.
We're acutely aware of
And I don't wish you to fall foul of the embargo. I'll put it that way. Thank you very much indeed, both of you, and thank you to those behind you. And we will deal with this as soon as we can.
Thank you, my lady.